October the 10th, we'll reconvene the legislature, obviously go through with the proceedings we have. This will be the focus of reconvening the legislature, is to introduce and pass this piece of legislation on parental rights, protecting parental rights.
So for a closer look at the legal perspective, we are joined by Adam Goldenberg, legal lead for You Are Pride. Good morning to you. Good to have you on today.
Good morning, Lindsay. Thanks for having me.
All right, so I want to jump in because this announcement came after a judge had granted an injunction hitting pause on the new policy that requires parental consent when children under the age of 16 want to go by different names and pronouns at schools. So what does the notwithstanding clause do?
Nothing immediately. So the government actually has to convince the legislature, a majority of the members of the Legislative Assembly in Regina, to vote for legislation that contains a notwithstanding clause, allowing them to override the Charter of Rights and Freedoms and enact this policy despite its unconstitutionality. And let's be clear about what that means. The legislature, a majority of MLAs in Saskatchewan, would have to vote for a piece of legislation that contains a provision saying this goes into effect even if it overrides, it violates the charter rights of children. That hasn't happened yet. As of today, in Saskatchewan, students can be known by their chosen names and pronouns in schools, even if they come from families where they can't obtain parental consent, or they're not yet out to their families, or they're not yet out to their parents. That's a good thing, and that's the reality in Saskatchewan today. The announcement from the Premier yesterday has no effect on that whatsoever.
Canada is the first country in the world to provide census data on transgender and non-binary people. Adam, in 2021, just over 100,000 Canadians over the age of 15 define themselves as transgender or non-binary. So when we look at that stat there, the one that's on the screen for everybody, that's about 0.3% of our population. But we're seeing constitutional cases in Saskatchewan, new policies in New Brunswick, and conversations in Ontario at the federal level. Do you know why this issue has suddenly become front and center? And are there any specific cases of harm done to children under the existing rules that we're aware of?
So there was evidence filed in court in support of the government's position opposing the injunction that was granted yesterday. And the court essentially finds that none of the harms, the terrible scenarios the government told the court would happen in the absence of this policy, were supported by evidence. And we argued in court that this was a solution in search of a problem, and that's what the evidence tells us. What's scary, though, is that as you just showed your viewers, you've got a situation here of a tiny minority of students who are directly affected by this policy. It's not just the gender diverse students as a whole who are affected by the consent requirement. It's really only those students who are gender diverse and who have the misfortune not to have supportive parents that are going to be out at school or out to their teachers or a specific trusted adult for any length of time, really, without their parents being involved. Those are the kids whom the court found were going to be irreparably harmed, or at risk of irreparable harm, according to expert evidence, if this policy were not put on pause. So what the government is now saying is that we don't care, basically. We don't care about that irreparable harm to that small number of students. We're prepared to do that for whatever. I'm not an expert in Saskatchewan politics. Clearly, the Moe government would rather be talking about this than something else. And so this is their strategy, to take that out on a tiny minority of kids whom the Supreme Court of Canada recently decided in a case called Hansman are among the most vulnerable young people in our society. That's reprehensible. It's unconscionable. It's not what the notwithstanding clause should be used for. And it's something for which, frankly, the government of Saskatchewan and anyone in that legislature who supports this proposed legislation is ultimately going to look back and think, gosh, that was not a good call that we made to support that back in those days. This will not age well, just as every other regressive and discriminatory action by a legislature has not aged well in our history.
So, Adam, in terms of your organization, you are the legal lead for You Are Pride. What are your next steps?
So our next steps are to continue with our case. So You Are Pride, which is my client, has a deadline of the end of next week to file our additional evidence in support of our underlying case seeking to have this policy declared unconstitutional. The government has the same deadline. We're going to meet our deadline. We expect them to meet theirs. It's important to know that the policy actually hasn't been declared unconstitutional yet. The government still has a chance with their excellent lawyers, and they do have excellent lawyers, to make their case, to try to persuade the court that they have done something constitutional by enacting this policy. That decision hasn't yet been made. So once the evidence is in, we'll potentially cross-examine each other's affiants, including our experts on each side, and then we'll have argument in November. So that's the timetable that the court has established. And since as of right now, nothing has happened that would change that, onward we go.
Adam Goldenberg, we appreciate your thoughts this morning. Thank you.
Thanks
bring
for
in
having me,
Adam
Liz.
Goldenberg. He's the lead counsel for You Are Pride, which sought the injunction. He is also a partner at McCarthy Tétrault law firm, and he joins us now. Adam, what is your reaction here to the Premier saying that he's going to use this notwithstanding clause to override things?
It's horrifying. The idea that a government in Canada would use this extraordinary constitutional power, a power that has been used very few times in the decades that it has even existed in our Constitution, to pass legislation that it apparently believes or agrees will violate the constitutional rights of children is despicable. It's unforgivable. It's unconscionable. And the fact that the government hasn't even had the confidence in its own lawyers to argue this case on the merits. Remember, the case is ongoing. The court hasn't declared its policy, the government's policy, unconstitutional yet. All it's done is said, until we know whether this is constitutional or not, we should not be inflicting irreparable harm on young people. The government apparently believes it doesn't stand a chance of defending the case, or it just doesn't care what the court will ultimately decide. It's going to pass legislation, it says, that would implement this policy, despite the courts having found that children will be irreparably harmed. That's what you have to prove, what we did prove, in order to get this injunction. Irreparable harm to children, and the government now intends to inflict that harm intentionally using the constitutional provision to do it.
We're going to get into the government's argument in just a second, and just to make everyone aware at home, we have reached out to the Premier Scott Moe for comment. We've also reached out to Saskatchewan's Justice Minister. We have not heard back from them. But I do want to get your take here, because Moe says he intends to recall the legislature on October 10th to pass this legislation. So how do you see this playing out?
Well, it makes no difference for our immediate next steps in our litigation. The policy remains on the books. It's been enjoined, which means it can't be enforced. That means that as of today, gender diverse young people in Saskatchewan who have a trusted adult at school, whom they want to respect them and recognize them for their gender identity, can have that trusted adult, the counselor, the coach, the school nurse, refer to them by their chosen name and their chosen pronouns, even if they haven't yet come out to their parents and so don't have parental consent. That's a good thing, and that's the reality in Saskatchewan today. At the end of next week, both we and the government get to file more evidence on our constitutional challenge. We're going to meet that deadline, and we expect the government to do so as well. As of right now, the statement by the government has no effect on yesterday's ruling, and it has no effect on our litigation, which is ongoing.
So let's talk about the statement, because the statement by the Premier reads like this. It says, our government is extremely dismayed by the judicial overreach of the court blocking implementation of the parental inclusion and consent policy. What do you make of that?
Well, as a lawyer, I would never make a public statement accusing a judge of a superior court in Canada of judicial overreach. It's also just a mischaracterization of what the court did here. Injunctions are unusual against the government, but they are a well-used legal tool that courts can apply in order to prevent, as I said, irreparable harm from being caused while a dispute is being litigated. Injunctions are granted every day by courts across the country. And the court in this case didn't say, it hasn't yet said, that the government doesn't have the power to implement this policy, that the policy is unconstitutional. We hope it will, and we will argue that it should. All the court has said is this policy, based on the evidence that has been filed to date, including expert evidence, will cause irreparable harm to gender diverse young people. And so we have to pause it while we figure out if it's constitutional or not.
Lawyers for the province argue that this policy has been misrepresented. They say that parents should be involved in their children's decisions, whether or not they decide to change their name or their pronouns. What do you say to that?
Well, the judge rejected that argument that the policy had been misrepresented. The judge, in thorough 56 pages of reasons, explained that the policy does just what we argued that it does, and what the policy says on its face it does. So there's no misrepresentation here. There's also no disagreement that a supportive parent is the single best tool in the arsenal of any child and any teacher when the child is gender diverse. Nobody is arguing that parents should not be involved in raising their children, should not know when their kids are gender diverse. The argument is some parents don't create a home environment where a person who is gender diverse can be safe at home. And those students should not be outed to their parents, and they shouldn't be misgendered at school when their parents aren't going to give the consent because it isn't a safe home. And we also recognize that for any LGBTQ2S+ person, and I'm one of them, coming out to your parents is a huge deal. It's the single most monumental moment in many cases in the life of a young queer person. And for the decision about when and how to come out to be taken out of the hands of a young person and placed into the hands of the government is outrageous. And that's why the policy is unconstitutional. constitutional.
What is your concern in terms of the precedent that using this notwithstanding clause could set in terms of this legislation? I know you've mentioned it a few times, irreparable harm, but what is your concern when it comes to the precedent?
I'm not aware of another case in which a government has said we will enact legislation even if, notwithstanding, the breach of the charter rights of children. I don't think that has ever happened in Canadian history. And it's not just that these are children. These are children who are members of a very small, very vulnerable minority. Anyone who is a member of any minority group in Canada needs to be very concerned about the idea of a government saying we're going to use this extraordinary power to breach the charter rights to equality and to security of the person of a minority group. It's a terrible precedent. It shouldn't happen, and I hope it won't happen. I hope that people in Saskatchewan will call their MLAs, that the members of that legislature will not go along with the government's plan, or that the government will think better of its approach here and will figure out a way that we can ensure that parents are involved when they safely can be, figure out how to protect children and give them the recognition and respect they deserve in school without inflicting irreparable harm on them intentionally.
Adam, thank you so much for your time. We appreciate your perspective as well. Thank you very much. Adam Goldenberg is the lead counsel for UR Pride Center for Sexuality and Gender Diversity, and he is a partner at McCarthy Tetraul Law Firm.